Good morning, everyone. Wednesday, 10 a.m. Mountain Daylight Time, and that means just one thing: that we're back again with another episode of the Canadian Immigration Live Q&A. Again, it's all three of us, Mark, Alicia, and I. We are Canadian immigration lawyers at Holthe Immigration Law, and we do these live episodes every week, trying to answer as many questions as possible, helping you as much as possible navigate this crazy world of Canadian immigration. While we're waiting for people to pile in, wanted to remind everyone to subscribe to this channel, make sure you like the video, share it, leave a comment, send us your toughest questions in the chat box, and we'll try to get through as many questions as we can. Now, while we're waiting for people to pile in, Mark and Alicia, how you guys are doing?
Oh, I'm doing well, Igor. It was interesting. I was listening to Mark's little interview, and there's been a bunch of noise, I think, about the temporary foreign worker program. So that's something that's been ongoing in the news and the media that people are talking about recently. Um, so it is interesting. I think it's been pretty busy with lots of consults right now. People are still trying to figure out what are their options, what are their ways to possibly apply for permanent residence, and it's been a lot of really hard conversations with people recently. I think that's the ongoing theme is that speaking with people who've been here, who've completed master's degrees here, who've been working in Canada for 1 or 2 years, sometimes up to 3 years, and they are really struggling to try to hit those points because the CRS points we know, funny enough, after our live last week, there was another draw. And remember, we were trying to rub the crystal ball to predict what the CRS score was going to be. And lo and behold, it was exactly 534, which is exactly what it was last time, which is so high for most people.
Yeah.
Mm-hmm. Mark, what
Yeah.
about
It's, yeah. Personally, we've had a lot of awesome things going on with the family, and things are now finally starting to settle down a little bit, which is great. Yeah. As Alicia alluded, I did an interview with CBC Radio, The House, with, what is it? Catherine Cullen, I think is her name. And I was actually quite surprised. Usually when you do these videos, they cut it down to a few minutes, but they left a lot of the interview intact. I guess they were happy about what I was saying. I don't know, but it's just hard. One of the questions they asked me was how I felt about kind of the state of immigration and just generally. And you know, as I think about it, I'm just kind of sad because for years Canada was recognized as a world leader in immigration, and we were so well respected globally for international student program, for immigration programs. And sometimes, you're kind of cursed because of your own success. And I think that's what happened to other countries too. Before us, it was Australia and New Zealand. And then, things get oversubscribed and they have to turn things down and shut programs down and close because of the success. And that's really what happened with Express Entry. A lot of the challenges that we have are because of how effective Express Entry was. And as people started to learn what they needed to do to obtain permanent resident status in Canada, and as it became more and more difficult to secure an ITA from outside of Canada, people realized, well, we've got to get more Canadian experience, whether that's international, student experience, and graduate from a Canadian school to get those extra 15 or 30 points, or, and then go to Canada and after you've graduated, get the postgrad work permit and get those extra 40 plus points. Um, the people started to realize that was the only pathway. So then our international student program really, really, really picked up. And for right or wrong, there was no check or balance put into that system, and now we're kind of where we are right now. And so what once was heralded as one of the best programs in the entire world is now just not so much, I guess, is the best way to say it. And as immigration lawyers, we deal every day with people who are seeing their dream of becoming a Canadian permanent resident slip away from them and not being able to do anything about it. Even when they've made all the right choices, they've done everything that they can. So that's kind of what makes me sad. And every day there's at least, 2 or 3 consultations I have where the people on the other side are in tears. and that's hard. That's really hard. Way more difficult for them, but for us, I've never had an experience like that as an immigration lawyer. So challenging times, but we're resilient. And where there's possibilities, boy, I don't think the government counted on us immigration lawyers, because we're doing everything we can to help people.
Well, and I echo what you're saying, Mark, too. And I think really Canada is looking for the best and the brightest, and the people who are going to put in the work and make the effort and go through, all the hoops that we've set out for them. And really, I think that is who is going to be left at the end of the day. I do think there are some policy failures where we're looking at what's going on with, we have a unique advantage and opportunity right now in bringing in highly skilled researchers and scientists and a bunch of people who are very, very well positioned to make the pie bigger, right? And I think sometimes we start getting worried about like zero sum thinking. We think that if we let immigrants in, then there's going to be less for us. And that I don't believe is true. I think if we have innovative, smart, hardworking people, it creates more opportunities, more innovation, more jobs, more opportunities for everybody. So I really hope that when we look at our programs, especially like the provincial attestation letters for master's students, that there's been an article too recently about what's happening with post-secondary schools and graduate programs in Canada and Canadian universities and underfunding. And so all of this has a huge policy implication for universities, for jobs, for economy, for innovation. So I really think we need not to be panning our immigration system. I really think we need to have clear fairness, transparency. We need to know what the goalposts are so that people can plan their lives and we can bring in the best and the brightest and the most hardworking.
The only problem I see with this, Alicia, is that unfortunately we don't. We don't bring the brightest people right now. We bring the people who either were, um, I would say, brave enough to decide to buy an LMIA, for example, right? Or who were, um, you know, uh, decisive enough to game the system sometimes. Not all of them, but there's a lot of people who game the system. And for those who are scientists and well-educated professionals in very narrow fields, unfortunately we don't bring them. Like we bring people based on what language they speak. I have just a couple of questions lined up here, and people are asking, what is the chance of seeing a trade draw? I have not seen a trade draw in more than a year. What is the chance of getting an education draw? I don't know. And we haven't seen an educational draw. We haven't seen an agriculture draw. So it's like it's questionable, like the strategies
Yeah.
that the government decides to pursue.
And
And
yeah.
yes,
And,
we are well positioned to attract the best
yeah.
people, but for some
Mhm.
reason we just don't. And I have
Yeah.
no answer for it.
Yeah. And that's a reality, Igor. There are some people that
Yeah.
have, a few bad apples kind of have caused, a little bit of harm to our programs, and our government is not very good at enforcing. And it's really difficult when you have individuals that are not playing by the rules. It's hard to identify them. It's hard um, to really enforce, especially in the world of job offers for sale. And when I talk to individuals, I'm always amazed at how uh, it's almost like common knowledge that amongst some of our potential immigrant population, that, well, I just didn't want to pay for my job offer like everybody else, like comments like that in my consultations, and I wanted to try to do it right. But now I'm looking on the outside looking in, and all of them are permanent residents after they paid for their job offer, didn't play by the rules. And I think that segment, at least anecdotally, is it's a small segment of the individuals that are coming in. Generally speaking, people are just well educated, really good, honest, sincere people. Working in jobs maybe under their qualifications in order to find a pathway forward, and it's always the individuals that are looking to get an advantage, maybe through means that are not as honest, that can spoil things for other people, like the removal of the entire job offer. Sometimes our government has a tendency to just throw the baby out with the bathwater. And Alicia, we think about our one client in Vancouver that's the CEO of a company, and what pathways does she have for permanent residence right now? And how, like Igor, you talked about our trades. Like I've got trades clients that are just wondering, well, okay, well, what options do I have? And it's hard to know. And the only thing I do know, you guys, is that if you speak French, you're just fine. Outside of that, I'm just not sure. So that's kind of where we're
Yeah.
at.
And I do think for sure, Igor, there was abuse of the temporary foreign worker program for especially low-wage LMIAs, and they've really clamped down on that. And we've seen cases where, you know, the government is enforcing that, and you're not home free if you have your permanent residence. IRCC can come back and they can take it away if
Yeah.
the reason that you got your permanent residence was through fraud and through misrepresentation. So, maybe people try to get in that way, but I really think that they will not stay. They will weed them out.
I'm just a little concerned with how, and again, sorry, I'm just speaking as I feel, right? Not trying to filter what I'm saying here, but I just am a little concerned with how the blame always shifts from the government, who's unable to enforce the program, to the actual people who try to come here and benefit to our economy and society. International students, we got too many of them. They are the ones to blame. Temporary foreign workers, we have two or three bad apples in the whole basket. All foreign workers are evil. Maybe it's not the right focus. Maybe the blame should be directed somewhere else. For ineffective management of the program. And when we have political actors using this to achieve their political goals, I'm not calling any names here, but you know who I'm talking about. Like, oh, we need to scrap the whole program, because it's all evil and it's all incorrect. Well, I don't think it is exactly that, right? Like there are so many bright individuals who would be amazing to contribute to our economy, like scraping away 50 points for job offers, for professionals who take senior leadership roles in multinational corporations who can advance our companies on international arena. They're not able to stay here, and they will move to the US. They will move. Right now, I'm working with a client. They used to be permanent residents. Something didn't go wrong, didn't go well, and so they were given an ill advice, to rescind their PR status instead of trying to keep it, and fighting to keep it. Now they're trying to come back. They came back with lots of savings. They lost it all, trying to stay in a very low-paid senior leadership role. Their employer was just like, I'm just paying you the very minimum that I can afford, that is permitted for this knock. And so now they're like realizing they don't speak French. So their only option is to move out of Canada and relocate back to the UAE. And that's the problem that we as a country face right now, that people are choosing not to stay here and move somewhere else where they can get paid more. For him, he has a question like, why would I stay in Canada and get paid like, I don't know, less than 100,000 when I can move to the UAE and get paid 170? And if I had Canadian passport, I would be paid double of that, $300,000. And I don't have a question. And so the priorities are very, very questionable.
Yeah, I agree with you, Igor. I think we need to reframe. I think we need to look at immigration as a huge opportunity. And if it's fair and if it's transparent and we have a brand that says, come to Canada, if you are the best and brightest and you're going to follow the rules, then I think that makes a ton of sense. And it widens the scope for everybody.
Right. All right. So I think we had our little rant in the beginning, just as usual. Now, I think this is a good time for us to actually answer the questions and help people understand what they need to do to stay here. So we'll give a couple of shout outs to Levine from Ontario, to Vera. Vera says, hope you all doing well. We are. Aisha says hello. And then Precious says hello. Let's see. And then we have many, many other people who are watching live, but they did not leave comments yet. So we encourage you to do that. And while we're waiting for you to send your questions, we'll start answering the questions that we already received. So the first one would be from Nash. For Alberta Advantage Immigration Program, as a registered engineering training with APEGA, working in a role that requires engineering training, do I get the 10 regulated occupation points? How do I confirm that AAP does this to AAP? Does my employer need to provide any additional proof? Because Nash essentially is considering relocating from Ontario to Alberta to work in Alberta for a nomination. And he studied in Alberta and able to get 1 year of work experience in Ontario plus 6 months in Alberta. So he's asking for a friend.
Yeah.
Yeah, and so Nash, there is some information on the AAIP website if you go to the frequently asked questions. And so this is important because there is definitely some confusion. I've had some other immigration lawyers that I've been corresponding with about AAIP and, when do you claim those education points? Do you get the highest education if your education was not in Alberta and it was foreign education? What does that highest education mean? But also for the regulated occupations. And so if you take a look at the AAIP FAQ, so the frequently asked questions page, it does talk about regulated occupations. And when it talks about the occupations and the professional, so there's professional occupations and then there's other regulated occupations. And what it says is go to step 2 of the foreign qualification recognition. And that's where you have to go down and see if your job, the occupation, and the body that's doing the certification is on this list under step 2. So that's what it is. If he is an EIT and properly trained as an engineer and is registered with APEGA, that ought to be on the list as a regulated professional, but make sure that he can prove that he does actually have his licensing with APEGA.
Yeah. And that's the thing too, to what extent is an engineer in training considered an engineer? And I think that's where the rubber hits the road, Alicia, is whether or not someone who is an engineer in training would still be considered at the level of an engineer to get the points. And I'm not sure if it's clear. I'm not sure if it's clear on the website as to whether or not that is sufficient. And I don't have an answer for it, to tell you the truth, right now. I don't know if you've run into this, Alicia, or if anyone has been able to get confirmation from the province, but that's one I'm not certain of.
Nash, you can actually have your friend write to the province and pose that question specifically and say that they've gone through and, make sure you drill down through the website and the links. But if it's not there, then send them a note.
Yeah.
Mm-hmm.
Or you can also reach out to us for a consult. And before we connect for a consultation, we send you a quick intake form where you can write the essence of your question and your situation. And we use that information to prepare for the call. So share our website with your friend and we'll be happy to speak with him.
Because clearly in engineering training, like it's within the same knock code as an engineer. So that's not the issue. It comes down to whether or not the province is going to accept that. It's like an apprentice for trade. You're not going to get credit as an apprentice for trade certification until you actually have that certification. So I'm unclear about that. I'm almost of the mind that unless you're a full engineer and you can stamp, that the province isn't going to recognize you as an engineer. That's kind of the advice that I've been giving clients at this stage. Unless someone comes up with something different, because unless you have that ability, then I think what they're trying to get at is you have the ability to work independently in your profession, and then engineer and training can't stamp. So that's my personal kind of view on that. But I'd love to see a more broad interpretation.
Okay. We also will give a couple of more shout outs to Norman and Harpreet and Simba. Okay, and we'll move on to the next question. This one is from Vera. Could you please explain how the 3-year window works for CEC candidates who left Canada? My work permit expired on July 4th. Does that mean that I'm eligible for CEC draws until July 4th, 2028? If only there was a course. I know Mark would say that.
I wish there was a course that could help people to understand that. Well, in absence of that course that people could go to, the short answer, Vera, is that you need to demonstrate that you have 1 year of Canadian work experience within the 3-year window that you're referring to. So if you were to leave on July 4th, that's when you left, then you can't say that you're eligible until July 4th, 2028. It's more like you're eligible until July 3rd, I guess, or I guess it could be July 4th. I'm trying to figure out where that day rolls over, but 2027, because you still need to have one full year within that 3-year window. So you can leave Canada and be outside of Canada essentially one day less than 2 years, and still be eligible.
Mm-hmm.
So Vera, the easy way to think about it is on the date that you are applying, if you look backwards in time for the last 3 years, can you prove one full year, 52 weeks of full-time work experience within that period? Because what we don't know is even though your work permit expired on July 4th, we don't know if you were working continuously from July 4th, 2024 to July 4th, 2025. But, that's what we're assuming.
And one other thing to be very aware of is that the lock-in date is when you submit your EAPR, not when you get your invitation to apply. So if you're fighting and you've got 3 days left and you got your ITA, well, that application, your EAPR, better be submitted while you still have that full 1 year. Because if you do not, they can find you ineligible for CEC.
Mm-hmm. Okay. We'll break the order a little bit because we've received a super chat from Claire. If you have an HNC application and then later get married and update RCC, does that speed up the process from the long HNC wait times?
Claire, it depends who you married. So that really depends if you married somebody who's not a Canadian, or maybe you married somebody who is a Canadian. And then it can also affect all sorts of things with your agency application, because a humanitarian and compassionate application really is very fact specific. So it depends on all the dynamics of why you were claiming that you couldn't meet the normal eligibility for a permanent residence category, and the only thing that you had was the agency. It also depends on factors. Igor's written a really good article. So if you go to our website, maybe Igor, you can pull that up, and he drills down through, all right, what are the factors that IRCC looks at? One of the key ones is the best interests of the child. So how does the fact that you've married somebody affect the best interests of the child if that was part of your application to start with? So there's no yes, no answer for this. We'd really recommend you book a consult if you want more targeted advice on this, but you can take a look at the factors that IRCC considers, and you will have to update IRCC with your updated family situation.
Yeah. And maybe we can also talk about here about the other question that we always being asked when someone is wondering about whether they should apply for the agency. They often ask, if I have a pending agency application, does that bar me from submitting any other application? So who wants to tackle this one?
Well, it's not a bar. The issue is whether or not you've maintained status. Mm-hmm. And are you in valid temporary status? And there's it's not like a refugee application that can prevent you from maybe participating in some of the PNP programs and other things like that. There's no outright bar just because you filed an HNC.
Yeah. All right. Let's move on. So the next question is from Cynthia. If you were working 2 weeks directly after your studies, but before you applied for postgrad, mm-hmm. What are the implications?
So Cynthia, go take a look at can students be working after the end of their studies? So I wrote an article. It is still legally correct in terms of what the guidance is from IRCC. So the rule is that as soon as your program finishes, and they count that as the earliest of 3 events. 1 is when you get your letter of completion from your university or post-secondary. 2 is when you get your final diploma or degree. And 3 is your official transcripts. So any of those 3 things, the first of those 3 things that happens, that's when they consider that your program of studies is completed. And one of the things that I really want to emphasize that has come up in a few of my consults now is actually in the regulations on the end of a study permit. And so if you actually take a look at the regulations and you go down to section, I think it's 221 on the, no, 222, the validity of a study permit. So a study permit under section regulation 222 actually becomes invalid on a day 90 days after the day on which the study permit holder completes their studies. And a lot of people don't know this, but for working, you can no longer work as a student if you finished your studies. That's what IRCC says. There's a whole IRCC page on who can be working when it's unauthorized work. They say that the instant your school tells you that you have completed your program of studies, you have to stop working that day. You cannot work at all until the day that you submit a complete PGWP application. If you've already submitted that PGWP application and you didn't put the fact that you were working, it's possible that they can say you've misrepresented. You should acknowledge that you worked without authorization. It was an oversight. You didn't realize it was 2 weeks. Give a whole letter of explanation. But technically, the risk is that IRCC could say, you know what, you worked without authorization. We have to wait for 6 months until after the unauthorized work. So in this case, it would be two weeks. The good news for you is that the processing times for a PGWP are about 6 months. So as long as you're honest and you come clean, it hopefully will not affect the issuance of your PGWP, but you do need to be honest about it. And you cannot claim any unauthorized period of work when you're looking at express entry and Canadian high skilled work experience.
Mm-hmm. Okay. We have one more super chat from Ankit. He's wondering, can I claim CRS skill transferability points for my outside Canada co-op studies, even though it had a graduation requirement outside Canada degree?
So outside of Canada, things are a little bit more flexible than inside. If you were paid and if it meets all the other requirements of work, you perform the duties, set out in the NOC, the skilled position, you were paid, it was at least 30 hours a week or the equivalent in part-time. As long as it meets those other requirements, it doesn't matter if it was something you were doing while you were going to school at the same time, as long as you were paid. So if you can demonstrate that, then it can be claimed as foreign work experience.
Mm-hmm. Okay, let's move on. So, wow, we have many super chats. I'll pull the next one soon. So, Emmanuel is wondering about the hike in proof of funds from 2022 to 40 Canadian. Not exactly sure, but we can go to
Yeah. So the settlement funds, once again, I don't know what category, what program we're looking at here. If this is like parent-grandparent sponsorship, if this is express entry. For express entry, it depends on the number of people in your family. So you can see the number of family members in the left column, and then the corresponding amount in settlement funds that was last updated this past July indicates how much funds you need. So yeah, if you have a family of 7, you're over 40,000, but it's not.
I'm guessing Emmanuel's talking about study permit proof of funds because that did have a big hike.
Okay,
Yeah.
there you go. Yeah.
Yeah. So what happened, Emmanuel, was that the government of Canada had that study permit proof of funds around for a long time. They don't usually call it settlement funds, but they call it proof of funds for study permits. So if that's what you're talking about, that number had kind of been the same for a long time. And what happened was a lot of students were living in not really good situations. They weren't living in a nice single apartment. They were kind of all bunking in the same room with multiple people. And the government said, okay, you know what? We have housing issues, and the cost of living in Canada is actually quite high. And it's important that students understand that going in so that they have enough funds to be able to afford to live and to eat and to have lodging in Canada. And so they did do a pretty big hike. And I can't even see that, Igor, but yeah, there we go. Thanks. But that number did jump quite a bit in terms of what it had been historically. And the reason was, one, they had to increase for inflation because that's been higher than it has been historically. And two, they realized that the number they had given for what a realistic amount of money was for one person in Canada as a student was actually quite a bit higher.
Yeah. And one other thing to identify too is that they really didn't want students coming and then using work outside of studies as the means for funding their education. So they wanted to put more emphasis on the study so that people, when they came, they had the resources to be able to fund their education without needing to work off campus, even though there is a provision that allows for limited work.
Mm-hmm. We have 3 super chats in the queue. Okay, we'll go through each one of those one by one. So Mountain Living MT, MT probably stands for Montana, says, we live in Montana, 5.5 hours south of Calgary, and visit Calgary frequently. Does the 6-month visitor visa start over each time we cross the border? We have heard different stories regarding this. Great question.
So
Mhm.
mountain living, it really depends. I'm assuming that you're a US citizen. But if you are not a US citizen, this is a totally different answer. So US citizens do not require a visa, right? So US citizens are TRV or visa exempt. So you can enter with your US passport, and usually people who are visa exempt also need an electronic travel authorization. The nice thing for Americans is that you're usually exempted from needing either a TRV or an ETA. So you can just cross with your passport as long as you can prove you've got temporary intent. And the rule is, yes, every time you come to the border, it's a new examination. So if they've not issued you some sort of visitor record, then every time you show up at the border, it's a new application, a new entry. You've got to show you're coming as a visitor. They give you automatically 6 months as the rule, unless they mark something else in your passport or give you a visitor record that's for a shorter period of time.
Yeah, and it's good that Mountain Living is a U.S. citizen.
US
Well,
citizen. Yeah.
there you have it. Okay, next question. Yuander Channel asks, is it okay to apply for T13 work permit without the R240C letter from Alberta? They're taking time to provide the letter.
Mm-hmm.
I've
This is
this
this is interesting. So of course, no is the answer. But here's some historical context. There was a time where we could routinely get work permits for Alberta with just the nomination without the separate letter. I remember when the program was first created, we could send people down to the border, and it was actually the border who initially said, well, no, we can't do this anymore. You need to have that extra letter, the R204C letter. But when we filed through then Vegreville, the In Canada Processing Center, we could request work permits, extensions or otherwise, with just the nomination. But those lovely days are long past now. So everything is held to the letter of the law. And no, you wouldn't want to do that. Some people think, well, if I submit it now, and there's probably, you've got reasons why you're trying to do it, like a work permit expiring or something. Well, I'll do it like an LMIA. I'll file my work permit application, and then once I get the 204C letter, then I'll include it. But it's just never ever do you want to go down that path, because often it can just cause huge problems for you long term, especially with the new, more harsher interpretations that they have for maintained status. So
let's see. There was one more super chat. Okay. ONP foreign worker stream. Experience 1 year outside Canada plus 1 year inside Canada. Is it okay? Any luck for express entry skill trades? My score is 469.
yeah. Want to tackle that one, Alicia?
So, Adnan, you'd have to go
Like
and pull up
ring the
the
bell.
OINP foreign worker stream, take a look at, are you meeting program eligibility requirements? When you are, OINP has, of course, employer-driven streams, and then they have the express entry link streams. So, do you meet program eligibility for those? There's nothing that says that you can't have an express entry profile and put in a expression of interest for OINP. So usually if you're eligible, you're going to want to try to have both of those eggs in both baskets and see if either of them is going to materialize. But that said, you do probably want to be strategic. So if you have an employer who's willing to go through the process with you, and it's going to be a PR portal application and it's going to take way longer, what are you doing with your work permit? How are you going to make sure that you give yourself the best strategic opportunity? So I would recommend you book a consult. So that's why we rang the triangle.
Yeah.
Mhm.
And for those of you who wonder how to retain our firm, how to book a consult, how to reach out to us, first you want to scroll below this video. You will see in the description we have hyperlinks that will take you to our website. If you can't find those links for some reason, you may just Google Holthe Immigration Law or just punch in our website address, holthelaw.com. And then when you get to our website, you can click here, speak to a lawyer, and then you can select with whom you would want to have a consult, the duration for the consult, and you can also hover above permanent temporary residence or refusals and delays. And there's this wonderful black button that says our legal fees. And there you can check how much do we charge for our services. And again, the fees that we quote here are the starting fees. So sometimes there are situations that are a little more complex, and sometimes we have to adjust the fees a little bit. But this is to answer your question, how to reach out to us. And there wasn't one more comment where the person was saying that, for example, here, Yukong was wondering how I can retain us for express entry FSW application review. So there you have it. holthelaw.com, and then speak to a lawyer, book a consult first, so that we can make sure that we actually can help you, that there's nothing that prevents you from proceeding forward with your application.
Yeah.
And
Yes,
I know
because there
last
are
time,
conflicts.
yeah, I know last time we got this question as well, Igor, and some people were saying, oh, well, I already have my ITA. I just want you to review everything at the very last minute and just make sure that it's all fine. And can you just charge us your hourly fee?
Yeah.
And
Yeah.
that is not how we work,
Mhm.
because those are the situations where I can almost predict with certainty that somebody has made a mistake on their express entry profile. They have failed to cross-reference a postgrad work permit or a previous study permit or a visitor visa application, and there are things that are inconsistent in their profile that is then in their EAPR, and there is a whole bunch of work. Like, we take so much care and effort in going through absolutely everything when people retain us. So our fee for express entry review is the same fee whether you have an ITA or you don't have an ITA. And the reason is we prefer working with people earlier in the process so that we can catch and head off those mistakes before they're made, so that we are confident that when you submit that EAPR application, we've not missed things, that you and I, or Mark and you, or Igor and you have worked together with a fine-tooth comb and gone through everything, because we look at that with an officer's eyes. Right? We play
Yeah.
devil's advocate and say, well, wait a minute, you said you had your study permit here, but you are claiming work experience and that timeline doesn't match up, right? Or now you're going to have to explain what happened with work. Or you said you were working in a foreign location, but you put your address somewhere else, and now that's going to mess up your police certificate. So there's a bunch of things that takes a lot of time to go through, and that's why we charge our full review fee.
Yeah. And where there are issues after you've received an invitation to apply, then it becomes a little bit more challenging because we'll have to try to correct those. We're in a world now where we are absolutely loath to decline an invitation to apply unless we have no other choice. And trust me, I've had consults even this week where I've had to advise people that they really need to decline because we just can't save it. And so there's nothing more heartbreaking than having the joy of getting that ITA and then having your immigration lawyer tell you, well, you probably are not going to meet eligibility, or there's some issue with your CRS score that will cause you to fall below that minimum, round of invitation level. But in other situations, there is things that we can do, and that requires a little bit more work and letters of explanation, all the things we talk about in the Express Entry Accelerator course and the master class, and how we approach things with our clients. And so it's we've kind of got a sweet spot with those applications. We kind of know how long it's going to take us, and like Alicia said, we forensically evaluate things. We go through and we look at every single document, especially the inconsistencies now, because whatever AI the government's using to scrub through previous applications, oh my goodness, do they key in on anything that you've put in your study permit that may be off from what you've put in your personal history, even, let alone the work history you're claiming points for. So now we just have to be much more careful, and that's kind of why we set our fee structure the way it is.
Yeah, and it's very ironic, but for those clients who come to us and say, my application is as straightforward as it can be, it turns
Yeah.
out to be the nightmare of an application,
Mhm.
especially when you review their profile and then you realize that they made mistakes, and you would probably not make those mistakes if they would retain you earlier in the process. Now you need to explain it all, and you spend double the time explaining some things that could have easily been avoided. And those clients who come to us and they are really anxious, they like, my application is this and this and that, and then
Yeah.
you're like, breathe out,
It's all
relax,
good.
it's all
It's
gonna be
okay. Yeah. Yeah, because those clients, they are already doing all the worrying that we do. And so they've addressed things, and they've contemplated the problems. And I love working with high stress clients because I know that they're careful. I know that they've spent the time. And when people book or subscribe to the Express Entry Accelerator course, like I had someone just yesterday that said, look, I took the course, it's awesome, but I'm still a little nervous, and I'd like you to to review it. And so in those cases, they've put a ton of work in. So we've got different kind of discounts that I offer, returning the course fee, things like that, when people retain us after, because they just want the peace of mind. And really, after all, that's the service we're providing as much as anything, is peace of mind, a good night's sleep. So when you submit it, you know that we've done everything we can to prepare a solid application. So
exactly. I will pull up two questions because they're somewhat similar. We've briefly touched on those in the very beginning of our lively discussion about the priorities of our government. So let's return back to the point of priorities. Is there a realistic chance of seeing a trade draw this year? The target for 2025 is 3,300, but I assume that all upcoming ITAs were counted towards the 2026 target. How do these numbers align? And then one more question was from this viewer. Will education category Express Entry continue in 2026? And what's the expected cutoff? So what do you guys think in terms of the categories?
So maybe I'll answer the last question first, Igor. And so, when they say they have a target for a certain number of people under a certain category, keep in mind that even though they haven't done a specific trades category draw, there are tradespeople who speak French and may have been invited in a Francophone draw. There are tradespeople who maybe have a gajillion CRS score points and were invited under a CEC draw. And so that's the problem, is that we can't open up the hood and see the exact profile of the not categories for everybody. All we know are this is the target that IRCC has set, and that factors into when they get applications under a draw for Francophone or CEC, they can see, oh yeah, this percentage were actually trades. And so that's what's happening kind of behind the scenes. My opinion on the education category, I'm surprised it's there. I don't think
I'm
it'll stay
shocked.
for next year. But
Yeah. It's interesting. My daughter is teaching here in Alberta, and they are, it's any day now. I was talking with another teacher that, a younger teacher that I actually coached playing volleyball, who's teaching now, and there's strikes looming in Alberta. And so education's a very volatile profession these days.
Mm-hmm. And it becomes a lot more complex for those people who are actually working in education industry here already in Canada, because you would need to have provincial certification, teaching certificate, to
Yeah.
be able to claim that work experience
Yeah.
for most of the NOC codes that are included in this category. And then you would realistically only have a shot if you have foreign work experience in education, because there you don't really care about the employment requirements.
Yeah. Well, one of our clients benefited from that program, right, Igor? It was looking pretty doubtful. Work permit expiring, and we were using some different means to try to get an extension, including a labor market impact assessment, which we, which was approved. But we had to file a C10 application for him to keep him here longer. but he had foreign education. He was an educator abroad, a specialist in math. And in his situation, he got an ITA with that round of invitations, which we were not expecting. And he just informed us, I think it was yesterday, he sent us an email saying he's got his e-Coper. So they're moving fast, you guys. They are moving fast with express entry processing. And the only reason it was delayed, and we weren't saying 2 and 3 month processing, was because of the medical thing. They weren't requiring upfront medicals, but now that they are, there's really no delay. So an officer can just whip right through an application so fast now, very, very little delays. So for those who are in that elite status of 534 points plus, or French, you are, when you get that ITA, you can pretty much expect you're going to get permanent residence unless there's some security or background delays, in as little as 3 months or maybe 4. Things are moving really fast.
Now, Mark, how would you answer this question then? Waiting for P1 for non-express entry from April 25. What to do? I'm not exactly sure. Like, if I'm not mistaken, P1 is the first email that asks them
Yeah.
to...
Yeah, I'm just looking at Taryn's saying, let's see. See, this is the thing. Applications can sit, and then an officer can basically run through all the steps in a day, clear everything through. And, depending on security, that's what to do. Well, you're still well within the processing time. So 6 months is the processing. So you're going to wait.
This
is
is
what you're going to do.
non-express entry.
This is non-express entry.
Oh, non-express entry. Oh,
PR
to a non.
portal.
Oh, yeah. What are we sitting at now for the PR
20
portal?
months.
Is it, how many is it? 20?
Like 20 months to process the application.
Yeah. Taryn, I think this is where people have to manage expectations. You really have to. So the way I approach this always, non-express entry, okay. The way I always approach this, Taryn, is you're in. Like you've got a foot in the door. You have a light at the end of your tunnel. And yes, it may be a long, lengthy processing tunnel, but you've been allowed in to go to start the journey. And there are hundreds of thousands of other people who would give anything to be in your situation and waiting 2 years for the permanent residence because they know that there's a chance. So in your situation, I appreciate there's probably other factors. Hopefully you've got your email back, your acknowledgement of receipt. You have the ability to extend your work permit if you need it. But in these situations, Taryn, it's really a matter of managing expectations because the government says, well, you've got a permanent resident application in the queue. You've got a valid work permit. You have an ability to extend. So we need to place our officers' attention and focus on other processing. So, yeah.
And I'm dealing with several mandamus applications right now, and this is one of the arguments that they always put in their respondent's memorandum. You cannot expect to be able to jump the queue, right? It would prejudice other applicants who submit their applications through other streams. We cannot just process your application just because you want to. That's how they phrase their arguments as to why there are delays. So if you're not experiencing unreasonable delays, then your only option is to wait.
Yeah. And unreasonable is based on the context of everybody having unreasonable delays. So
Yeah, and I see another comment from Taryn that I see that some people have already before me and then after me have already got the first stage email, and then there's GCMS notes, but you don't see it through the email. So sometimes if you've not worked with an immigration lawyer or you tried to do your application on your own, sometimes there is a reason why IRCC is taking longer to process your application, and it could be because you made a mistake, because there's an inconsistency, because they're worried about misrep, because they're doing background security clearance screening up front because of something that was in your application. So if you are worried and there's something specific, then reach out, book a consult, and talk about what was in your application. Sometimes it requires us like literally looking through your application to try to figure out, is there something that's a red flag?
And that's a great comment, Alicia. It reminds me of one of our ex-clients who's now a permanent resident. And in that particular situation, the person submitted a TR to PR application. Everyone got decisions. But this guy was like stuck in processing, and he's like, I want to do mandamus application. I want to do something. I want to speed it up. And then we look into his GCMS notes and we realized that he wasn't eligible. And so we had to find a way to correct his situation. And luckily, we did it in a very, very timely manner. And now he's a permanent resident.
Yeah, that was a miracle. Yeah, that was a miracle. He came to us just at the right time. Yeah, and we were able to save it. Yeah,
exactly. Yeah, we do have one more super chat. Sorry for everyone who sent their questions. I have them lined up in the queue, but we try to give priority to our super chats, and we'll get back to your questions as well. But Chowder EXN1 says, "Hi, Archibald here. I want to know if cooks will be part of trades and does it need red seals?" Well, cooks are part of the trades category. And to determine whether you need a red seal, you need to look at the NOC. So I prepared the NOC here on the screen. Mark, Alicia, who wants to tackle this section for the employment requirements?
Yeah, so take a look, Archibald. Mark and I actually did a whole podcast episode on express entry, getting it right, and we talked about trades. And the difficulty with trades is that you need to be careful in terms of what are you talking about. Are you talking about federal trades categories, or are you talking about one of the three umbrellas, or are you talking about maybe a CEC draw and you have category-specific trades experience? Those are actually two separate things in terms of assessing eligibility and how you break down like selection grid points versus CRS points. So right now, if you are looking at, if your question is, does it qualify for a category-based trades draw? Yes, cooks are on the current listed occupations. 6322 is the 63200, sorry, is the NOC, and it's listed under the category-specific trades. But you also have to have minimum eligibility criteria under FSW or CEC or the federal skilled trades category. So keep all that in mind. And then in terms of whether and how many points you're claiming, you do need to prove that whatever province you're working in, that you are eligible to work, because often it is a regulated occupation. And so you've got to go through and figure out, sometimes people are able to work as a cook, but they may not have that red seal designation. Sometimes there's a different occupation certification that could also qualify you to work as a cook. So take a look at the podcast that Mark and I did. It's on the Express Entry Getting It Right series.
Yeah. And if you wonder how to find our podcast, you can, blog and resources, and then you have the podcast on Apple Podcast and Spotify. So this is where you find it. If I'm not mistaken, we also have the link on our CII website as well. All right, let's return back to the regular questions that we've received. So let's see. This one is actually very good. Let me just change the screen. If I applied for FSW with my information in a pool, how does it affect a potential work permit application? That's in the case of transferring from a company in US to Canada as a foreigner. So does the information in the actual profile before you even receive an ITA affect your other applications? Can they check?
Yeah, they can, and yeah, they do. And so this is where we talk about dual intent, Precious. And so we want to make sure that if you do have a express entry application sitting in the pool and you are also applying for a work permit or some sort of temporary status coming from the US to Canada, then you want to acknowledge that. You don't want to hide it. You want to say, yep, you know what, I have an express entry profile sitting in the pool. It's not technically an application for PR because you've not been invited yet, but they could say, hey, you might have some sort of permanent in addition to your temporary intent. So how do you justify your ties to your home country? How do you justify the fact that you've complied with your immigration obligations in the past, that you will go back home, that you have connections, that you have property, that you have a job, all that kind of thing. So yes, it is something that they look at, and you do need to be mindful when you submit that application.
Mm-hmm. Would you
one thing I'll add to you guys is they tend to be a little softer on that dual intent, at least with the temporary intent, in situations of intercompany transfers than they would, say, a labor market impact assessment. Sometimes they're a little bit softer on that because the whole reason you're coming is because the company needs you to provide specialized knowledge, or you're a senior executive, or a senior managerial employee, and the expectation is that you're going to transfer back to the company once your work permit is completed. So sometimes the assessment, they're not as harsh, but it has definitely, one thing we never talked about, Igor, was the refusal rates. We kind of skipped through that. We were going to chat about that a little bit today. But refusal rates are skyrocket high. Like, they are looking for every reason possible. And this is a little chart. I think Stephen Murns
Yes.
shared this, didn't he, Igor? So shout out to Stephen Murns for releasing all this good information, and he gets his hands on all kinds of good stuff. But yeah, the approval rates are super low in some categories. But if you look at, let's see here, do we have the international
Mobility program, 69%.
Yeah, IMP. So if you look at the international mobility program, it has what's the percentage? Even then, it's 69%. Now that includes a ton of different work permits. Essentially, everything that's not an LMIA based work permit is under the international mobility program. But yeah, it's the refusal rates are really high.
Okay. And then we can scroll through the other categories.
Even if you stop there, Igor, for a second, we look at the work permit extensions, temporary foreign worker program. These are extensions, like 49%. Is that accurate? Holy cow. So, individuals that are applying to extend their stay on LMIA based work permits, 49%. Wow. And then look, study permits, 33%. That's approval rates, you guys. That's approval rates. So you can see how much they're desperately trying to reduce the number of international students in Canada. And yeah.
And this might also be a consequence of people filing dummy applications, right?
Yeah,
Placeholder applications.
Yeah, that's entirely possible. And then you look at the global temporary resident visas, visitor visas is 48%. Super visas is a little bit higher at 77%. Yeah, but it's pretty crazy. And then we would expect that permanent residence generally would be pretty high, but the programs, like if, for instance, the self-employed program, you can see approval rates are only 32%. Startup visa, 23%. Because anyone who doesn't qualify through express entry usually will try to wedge themselves into those programs. And I think lots of applications are filed that never should have been filed in the first place. So it's interesting to see these, how this is all played out.
It's interesting, this federal skilled worker express entry is 78%. So for those people who think, oh, express entry is just you punching in information in online form, it's kind of like this questionnaire on a dating app. No, it's not. It's not. Let's see, what else do we have in here? Oh, H&Cs. This is 23%.
Yeah. 23% approval rate for agencies. And I can't see any other way that it can be, because the annual levels plans suggest what, 8,000 maybe for this year?
10,000 for this year, 6 for next, and then 4,000 for 2027.
Yeah. And what do we have? Like 100,000 applications in the queue? Like
like the latest data that I've heard is it still is around 60,000.
60? Yeah.
Yeah.
Crazy.
Yeah. And you can imagine how many Ukrainians we have, and people from Palestine and Israel and China and all of those countries, and Myanmar, right?
Yeah.
So it's going to get worse.
Yeah.
All right. We do have several more super chats. People are very heavy on super chats today. So this one is from Philippe. So Philippe has years of part-time work experience in Alberta, now 6-month full-time offer. Can I still proceed with AIP, or does the temporary nature of the job affect my eligibility?
Yeah, it does. So Philip, go and take a look at the AIP employer job offer requirements, and it's clearly stated in there that employment has to be for 12 months or more in that job offer, and then part-time work or temporary work also will not fly.
Okay. There is a super chat from Yuander, so he wanted to send a follow-up. So here's the super chat, and let me see, I think I had a follow-up in here. So remember the question where Yuander was asking, can you apply for a T13 work permit without an actual RTO4C letter from the province? He's now wondering, what if he has an email from the AAP saying that they've received my request? Can I use that
No.
as a support to submit a work permit application?
No, you need the actual letter. You need the letter.
Mm-hmm.
Yeah.
And you wonder, we'd want to talk to you more about why are you trying to do it right now? Is it that your work permit's expiring? Like, is all of your status expiring, or do you have a valid work permit from another employer and you're just trying to wait and see what's happening with that new employer? If your status is expiring and this is like your last Hail Mary pass application and you're trying to figure out what to do, then we definitely need to chat to see if you have any other options. But if it's just a matter of you just got to be patient, you just got to wait for the R204C letter. And then once you have it, you submit the application. Depending on the circumstances, there is a temporary public policy where if you are going from one employer specific work permit to another employer specific work permit, sometimes you might be eligible for this temporary public policy to request interim permission to work for the new employer on an
Earlier.
employer closed work permit, but you have to wait for permission to come back from IRCC, and you need to do that all properly.
Mm-hmm. Yeah. Now that we're done with super chats, we'll return back to the questions in the order in which they were received. So this viewer is asking, does work experience gained while studying full-time outside Canada before coming to Canada counts toward immigration purposes?
If only there was a course. Yes. So work
yes.
experience gained while studying is not under the same restrictions as it is in Canada. So if you are working while you're studying full-time outside Canada, there's no restrictions on being able to claim it as long as you meet all of the other eligibility requirements to claim that foreign work experience. So Fantahoon, the short answer is yes, you can, as long as that work experience is paid. It's 30 hours per week or the equivalent in part-time. It's skilled, so it fits within the tier 3, 2, 1, or 0. And yeah, it is definitely possible.
Mm-hmm. Mm-hmm. Yeah, and for those of you who wonder where to find our courses, again, the link is in the description below this video. You can also find the link to the course on our website at holthelaw.com, or you can go directly to canadianimmigrationinstitute.com. And there you will find our courses. There was one other question that I'm really embarrassed to pull up, but I have to.
Okay, here we go.
Where's the citizenship course? It's not here. It is not. I have to be honest. I was just extremely busy this August, and
Yeah.
in September I just need to take a little break and restore my mental and physical balance, because otherwise you would have two lawyers left in Holthe Immigration Law, and the other one will be somewhere in a very deep treatment, trying to cope with life. It's not easy. It's my first year. Actually, wow, it's like my second year now that I'm being a fully licensed lawyer, and I'm still trying to adjust to the pace and trying to adjust to new realities that our families facing. Just a little hint to everyone, but yeah, it's not here yet, but I'm working on it, and this is one of my priorities for sure. Okay, we'll move on to the next question. I wanted to get rid of that one as soon as possible, but
and maybe we'll, Igor, we have another. Alicia and I have another commitment right after this. Maybe we'll do just a couple more questions, and then we'll wrap it up just a little bit early. Yeah.
So Par was asking, my wife is not supportive. She does not provide passports, medical, or PCC. We may get divorced. How can I still process my PR application and declare her not as an accompanying spouse?
Ding dong. That's definitely a book of consult. The concept of legal separation exists within immigration. When you've actually filed for divorce, that tends to be a pretty, a fairly decent piece of evidence to demonstrate that you are legally separated. But it is not easy, because immigration is used to seeing far too many people list their spouse as being legally separated and then magically reunite later when it's more convenient for whatever purposes. And so they tend to hold people to a high standard. And even in Canada, there is no formal, document or certificate you get from the court saying you're legally separated. It's more an operation of law. But other countries may have things along those lines. But this is something that you have to approach very delicately, Parva. And yeah, it sucks when you've got a dependent that is not cooperating and it's affecting your permanent resident application. But these types of things are pretty complex, and we recommend you book a consult.
Okay, and then we'll pull up just a few more questions. So Cram is wondering, if I about to apply for the bridging open work permit and I have the acknowledgement of receipt, do I need to submit a new police clearance certificate, or I can use the one that I submitted with my PR application? With the context, I did not return to the country where a police certificate was issued from since I came to Canada.
You don't need a police clearance certificate to apply for a work permit, but Alicia, what are your thoughts on this one? If you're in Canada applying for a bridging open work permit, there is no requirement for police clearance certificates in that context, unless I'm missing something.
Unless there's something showing as an arrest or a charge, and you need to describe why you're not legally inadmissible. But yeah, hopefully you submitted the correct police certificate when you came to Canada. I don't know. It doesn't seem like you've actually submitted a PR application though. So
well,
sometimes
it says here, it says, or can I use the PCC that I submitted in the PR application? So I think he's got the PR application, he's got a work permit, he's filing the bridging open work permit, and now wants to know if he can use that PCC for this. Well, there's no police clearance certificate requirement when you're filing a bridging open work permit from within Canada, because you're already here. And so, yeah, I don't think there's a requirement. So
yeah, and maybe we'll refer Cram to this webpage for how long your PCC is valid for. So some countries, yes, they put expiry date, but if it is from the country where you're not currently residing, it must be issued after the last time you spent 6 consecutive months there. And this is something that we also talked with Alicia the other day. Like, we treat this rule very narrowly, and we ask all of our clients to get their new PCC, even if they return to that country for one day, because we've seen far too many mistakes made by the officers, and it just doesn't.
It's not worth it. Because when you read this, it gives the impression that if you just go back for a few weeks or something, then it doesn't invalidate the previous police clearance that you had. But I'm sorry, I'm not trusting this interpretation. If you go back at any time, I want you to get a new one. And I like staying as far away from the cliff as possible, not running along the edge.
Yeah, what we don't know, Cram, is did they ask you for a police certificate, right?
Yeah.
Was there an additional document request that was actually asking you for a police certificate, or are you just providing it up front just to try to have more information in your application?
Okay, and to wrap it up, I'll pull one question from Josie Kai, and he's saying, I'm thinking about immigrating to Canada. Great idea. I'm currently staying in South Africa. I'm an electronic engineer, and I'm fluent in both French and English. What would be your advice?
Yeah, give it a run, my friend. Yeah.
Yeah, book a consult. We can talk about your family situation, your work experience, your education. Have you done your language testing yet? If you're fluent in both French and English, you've got an advantage right now because of the way that the express entry system is working for French speakers. But in general, if you qualify and you're eligible, there's no harm in submitting a express entry profile and seeing if you maybe get an ITA.
Yeah. Wonderful. Well, thank you everyone for your wonderful questions. I think we had a total of 9 super chats today, which is actually really good. We apologize to everyone whose question was not pulled up. We just have very limited time, and we try to go through as many as possible without rushing through, right? But if your question wasn't answered, or you have any new question, you can always catch us here at 10 a.m. Mountain Daylight Time on Wednesday. And we'll be here next week as well. On this note, thank you.